Your Honor.
Is it all right for me to proceed?
Yes, Judge. We've explained to Mr. Pino his right to testify and his right not to testify. That two competing rights, he needs to choose one. And with our advice, he has elected not to testify. I've explained to him that he could choose to testify, that you would colloquy him and explain to him from the court, I believe the same thing I've explained to him, and he's prepared to let you know that that's his decision.
Okay, very good. And I think you've already, I think I saw you this morning. All right, Mr. Pino, we're just about at that point in the proceedings that, while I think there might be another witness being called in the case, this would be the time that if you wish to testify, you are certainly entitled and permitted to do that. You remember that I had instructed the jury, even during jury selection, that every person who is accused of a crime, any person who is accused of a crime, has an absolute right to remain silent. At no time is the person accused required to make any statements or give any testimony at all. And that applies similarly to you, sir. And the jury cannot hold it against someone for choosing not to testify. Okay? So this is one of the decisions, there's 4 or 5 decisions that are held by the defendant solely. Your lawyer cannot make the decision for you. It's never going to be their decision as to whether or not you testify. But you took time, and I want to make sure you had sufficient time to speak with your attorneys about this important decision. Happy?
Yes, Your Honor. I spoke with my legal team at length. And,
okay, let me keep going. Have you had sufficient time to do that?
I have sufficient time.
All right. And while they will give you their advice, understand that's their advice. And sometimes I'll have someone say, well, on the advice of my lawyers. But the real issue is you have to make this decision as your own, knowingly, freely, and voluntarily. While, again, lawyers can give you advice. They can say what they think would be best for you, but it's not their decision. So, have they given you advice based upon their assessment of the evidence that's been presented?
Yes.
All right. And have you made a decision as to whether or not you wish to testify?
Yes, I have made a decision.
Okay. And what is your decision, sir?
I do not wish to testify.
All right. And has anyone forced you into that decision?
Nope.
Threatened you in any way?
No, Your Honor.
Said to you, Mr. Pino, not only are we giving you the advice not to testify, but we're telling you that better not testify or anything along those lines?
No.
Okay. All right. So this is your free and voluntary decision.
That is correct.
Do you understand, though, that you do have the right to testify if you wished to do so?
Yes.
Okay. Very well. In other words, forced you into this decision, you're making it of your own free will.
That is correct.
All right, very good. So, you can have a seat, that's fine. And I think we're going to, you have your witness, you want to check on your witness? She's here.
So here's where we are. The witness is here.
Okay.
She's the witness who had testified previously who had not had an opportunity to...
Right, okay.
So there's a recording that she would, I guess, listen to, I guess, authenticate.
It's her on the body worn, right?
That's right.
Okay.
And so...
Do you have it?
We do.
Okay.
It may require, because the volume is not very high,
Okay.
so that it may be clumsy in terms of how it's presented, because she would need to listen to it, maybe even with headphones on the TV. Or on the
She
TV.
could come up here on the witness stand with a computer, listen, observe and listen, and then you could just continue with the questions.
Okay.
Any issue with that, counsel?
Well, yes, Judge, because number one, I don't think that she can be impeached based on her saying, I don't remember. what they can do is try to refresh her recollection with something. I understand that which they want to show her may be in evidence, but she shouldn't have her recollection refreshed in front of the jury in that way. Normally, up until the time we had all this video evidence, it would be a matter as simple as showing a written statement or a deposition. So I would suggest to the court that they see if they can refresh her recollection outside the presence of the jury, play whatever portion of the video that they want, ask her if it refreshes her memory. Then they could put her on the witness stand and say, did you have an opportunity to view part of your interview with Lieutenant Thompson? I think that would be the way to handle it.
Let me ask, did you go back, because you were going to go back and look at the exchange that had taken place, whatever
We
it
did,
was?
Judge. Mr. Forrest has the exchange of what was said.
Judge, I looked at it. So basically, the defense asked about whether or not the witness saw the defendant on the floor, unconscious and bleeding. Her response was that she was then shown a transcript of her statement to detectives, asked if it refreshed her.
I'm sorry,
Yes.
Was that the transcript of this?
Correct. It's the transcript of, yes, Judge, it was that transcript. She was shown that transcript, and she said, I don't remember, but I guess I had to have said that. So to me, they did impeach her, and really, I don't think any extrinsic evidence is necessary because she said, I had to have said that in front of the jury.
Okay, so this is, I think, how it's best to handle it, all right? You're recalling her, what was she called as a state witness, right?
Yes.
So you're going to call her as a defense witness. You want to address this area, okay? But before I bring the jury in, all right, I'd like her to sit here and, without any conversation, review it, look at it, okay? And we can go through the steps of seeing